Good morning, friends. This side Pankaj Batra, advocate. I have been practicing in Honorable Delhi High Court, Supreme Court, and all other district courts for more than 26 years. I felt that with my journey of this advocacy, I felt that I have seen several times that the the Section 100 CPC, that the exercise of jurisdiction by Honorable Delhi High Court, sometimes the drafting or petition or appeal filed under this section 100, this is the second appeal, is not properly drafted, and sometimes the court has to dismiss that only on account of the reason that this either the substantial question of law is not mentioned in the petition appeal, or that is not argued by the learned counsel for the appellant. And sometimes it also happens that the Honorable High Court exercises its jurisdiction under Section 100 CPC without framing the substantial question of law. In this regard, I wish to prepare this short video to to make some parameters laid by the Honorable Supreme Court clear to the young members of the bar, so as it helps them uh, while preparing and application, the appeal, and the arguments in their arguments. So let's begin with Section 100 CPC. What it says. 100 CPC says. Now, before I start, I will also request my learned listener that I have also prepared a PDF. So to open that PDF, which includes some judgments rendered by the Honorable Supreme Court, these are the benchmark judgments also. So to read along with what I am, along with this, listening the video. Section 100 CPC says, subsection 1, save as otherwise expressly provided in the body of this code or any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law. Now, in this subsection, there are two things apply. The second appeal will lie only against a decree, and the decree is defined under CPC, under Section 2, subsection 2 of the CPC. Uh, and if from such decree it involves a substantial question of law. So the second appeal is limited to the framing of substantial question of law, arguing on a substantial question of law, and substantial question of law is the sine qua non for the exercise of jurisdiction for Honorable High Court. Now, subsection 2 says an appeal may lie under this section from an appellate decree passed ex parte. It's quite clear. Subsection 3 says in an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in an appeal. So, while drafting an appeal, it is mandated by the legislator that you must mention precisely what is the substantial question of law you intended to be argued or to be framed before the Honorable High Court. Now, subsection 4 says, where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. Now, when the High Court is satisfied, there is a substantial question of law involved. So, this is also one of the first thing which the High Court would be doing. That is, formulate that substantial question of law. And then subsection 5 says the appeal shall be heard on the question so formulated, and the respondent shall at the hearing of the appeal be allowed to argue that the case does not involve such question. Now, what it means? It means that after such a substantial question of law under subsection 4 is formulated by the Honorable High Court, and then it shall be open for the respondent to say, sir, this is not a substantial question of law and involving from the very case of the case. So it is permissible for him to argue that. Now, provided that nothing in this subsection shall be deemed to take away or abridge the power of court to hear, for the reasons to be recorded, the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. Now, this gives an expansive power of the High Court that if during the hearing the Honorable High Court is convinced from the maybe from the either on its own or from the arguments of respondent arguing that this substantial question of law which is framed by the Honorable High Court or pleaded by the appellant actually in fact does not arise in the facts of the case. And if the Honorable High Court, thinks that yes, of course, you are right that that question of law is not arising, but some other question of law so arises. So it can formulate that question also, that substantial question. Now, now then, at this very stage, I caution to the respondents and the appellants as well. If the Honorable Court itself frames an issue, substantial question of issue under subsection 5, then in that eventuality, both the parties, either of the parties, can request the Honorable High Court, sir, please give us some time to think upon it, to prepare for its arguments. We were not contemplating on that. So there are judgments to that effect also. So in that eventuality, the High Court would be, adhering to the principles of natural justice in that regard and give them your due opportunity for that. Now I have prepared some judgments, some parameters said by Honorable Supreme Court, and one of the judgment is also the Constitution Bench judgment, but the law has developed over a period of time since 1962, when the first Constitution Bench judgment was declared or pronounced by the Honorable Supreme Court. Thereafter, the Supreme Court thought it fit that to include some exceptions to that rule, which was laid by the Honorable Constitution Bench. So first, the judgment which lays that benchmark, which is still followed today, is the Hero Vinod versus Shishamal. Now this is reported in 2006 AIR SC page 2234, para 16 and 24 are relevant, mind you. Now what it says about, it distinguishes about what is a question of fact, what is a question of law, what is a substantial question of law, and what is an exception to substantial question of law which will be interfered by the Honorable High Court. Now, the question of fact is an inference of fact from the recital or contents of document is a question of fact, but its legal effect of the terms of the agreement or the document is a question of law. Now, the question of law is a construction of a document or its interpretation where there is misconstruction of documents or wrong application of principle of law is also a question of law. Now, what is a substantial question of law? A question of law having a material bearing on the decision of case. That means the substantial rights of the parties are affected if that point is decided. So that question of law becomes a substantial question of law. That is a question answer to which affect the rights of parties to the suit. Will be a substantial question of law if it is not covered by any specific provisions or settled legal principle emerging from binding precedents and involves a debatable legal issue. Now, this part, it says that when it is a debatable issue, only then it will become a substantial question of law, or when it is of public importance, then it will be a substantial question of law, or that the principles are not yet settled by the highest court of rank. It means the principle of law which you want the High Court to exercise its jurisdiction in second appeal, it must be a point which is not settled by the highest court. So that is the point. But mind you, there is a exception to this rule, because if there is, just think about a situation where the Honorable High Court, I am the Honorable lower courts, two lower courts below, have not looked into the legal principle of law which is settled by the highest court of land, and they didn't apply it, they misapplied certain situation in that eventuality. So these are the exception to this rule. Now these are the substantial question of law arise even in a situation where legal position is already settled on a point, and the trial court either did not apply the settled principle or applied contrary to such settled principle position of law in the given situation. Now that is a point where the Honorable High Court can duly exercise, and uh, this is a point included in this judgment by the Honorable Supreme Court in Vinod versus Hiroka, Vinod versus Shishamal, to render the parties justice, real justice. If the court below have fallen prey to a wrong principle or have avoided, acted contrary to a settled legal principle, misconstrued the settled principle, in that eventuality, that case would be a very right case for the High Court to exercise its jurisdiction under Section 100 CPC. Now, another point which I will thresh to my audience is, what is the case where the when sometimes the two courts below, the High Court says that two courts below have a concurrent finding of fact, and in that eventuality the High Court will not entertain the second appeal. Now this is the rule, but there is an exception to that. Now what are these three exceptions? These three exceptions are itself stated in Hero Vinod Supra. That is in para 24. It says the courts below have ignored material evidence or acted on no evidence at all. Like it borrows an analogy. It goes on giving a judgment when there is no such evidence on record. In that eventuality, also one of these situations. The second situation is the court have drawn wrong inference from proved facts by applying the law erroneously. Now, from the examination, if a party has discharged its honest correctly and proved the point, in that eventuality he is entitled to a judgment. But what the lower court has done is they misapplied some other wrong principle of law. They have ignored certain vital points, or they have had a wrong inference from the proved facts by applying the law erroneously. So that is also a situation. And third situation is that the third situation is also quite wide as such. That is constricted but still a wide. The courts have wrongly cast the burden of proof. Now suppose a plaintiff have must have been burdened with the honest to prove the facts. Now instead of that, due to some complexity of facts, the learned court, trial court have casted that burden which should have been on a plaintiff, have casted that burden on the defendant. Now in that eventuality, the plaintiff will not lead any evidence to that effect. So that is the situation, right? And it covers not only the cases where there is no total dearth of evidence, but also cases where the evidence taken as a whole do not support the findings. Now if you read the total evidence as such, it does not support the findings. The no reasonable person would have arrived at such findings based upon the evidence let. So that is also one of the point wherein the Honorable High Court, even though the two courts below have come to a concurrent finding of facts, can still intervene into that. Now, another benchmark which is laid by some four judgments, that the framing of substantial question of law is a sine qua non for the exercise of jurisdiction. The framing of substantial question of law or the decision on the basis of substantial question of law is mandatory for the High Court, and that exercise without such doing would be without jurisdiction. Now these are the four judgments I have mentioned in my PDF. I just read it. And Balaj Krishnan and another versus Kailash Nailkar, 2008, Volume 10, SCC 714, Para 31 and 32 are relevant. Honorable P.N. Agarwal and Honorable Justice G.S. Singhvi, the Honorable two judges of the Honorable Supreme Court. In this case, in case no substantial question of law framed, matter remanded back for fresh disposal of second appeal. S.K.B. Khan versus Mahmouda B. Civil Appeal number 3048 of 2017, date of decision 20th February 2017. Now, in this case, too, the matter was remanded back to High Court for not framing substantial question of law. The third case is Suraj Singh Dat versus Shri Bhagwan and others. That is 2018, Volume 4, SCC, page 562. Now, its relevant paras are para 20, 21, 25 to 35. This judgment was pronounced by Honorable Justices R.K. Agarwal and Justice Abhay Manohar Sapre. Now, it says that it's a framing of substantial question of law, and hearing on that aspect is a mandatory, and if exercising the jurisdiction without this, it will be a exercising without jurisdiction. Then fourth judgment is a Ram Sakhi Devi versus Chaitra Devi and others, Volume 5, 2005, SLD, page 377. Another citation of this jury judgment is AIR 2005, SC 4196. Para 7 is very important. Now, this judgment is passed by Honorable Mr. Justice Arijit Pasayat and Honorable Justice S.H. Kapadia. High Court shall formulate substantial question of law under subsection 4 of section 100 and shall hear on such questions under subsection 5 of section 100 CPC. In absence of that, judgment is liable to be set aside. Now, the fourth aspect of this is, which I was referring to, Constitution Bench judgment passed by 5 honorable judges of the Supreme Court, passed in 1962, and which spectrum has been broader by later judgments. That is Sir Chunilal v. Mehta and Sons Limited versus Century Spinning and Manufacturing Company Limited. Its citation is AIR 1962, SC, page 1314, para 2 and 7 are relevant. Now, this judgment is pronounced by Honorable Mr. Justice, Chief Justice B.P. Sinha, Justice J.L. Kapoor, Honorable Justice M. Hidayatullah, Honorable Justice J.C. Shah, and Honorable Justice J.R. Madholkar. So the two things are pronounced by this judgment, that is a construction of a document of title or a document which is the foundation of the rights of parties necessarily raises a question of law. It means a question of law will arise only from the facts and pleadings, and it cannot be a hypothetical one, and it should affect the substantial rights of the parties. Now, what is the substantial question of law? The substantial question of law is constitutively defined by the Honorable Constitution Bench. That is the question of law or substantial question of law, whether it is of a general public importance or whether it directly and substantially affects the rights of parties, and if so, whether it is an open question in the sense that it is not finally settled by the court or it is not free from difficulty or calls for discussion of alternative views. Now, the question arises is when there is no settled principle of law, then in such situations there is no verdict of the Honorable Supreme Court or the highest court on that point of law. Then in that eventuality, according to the Constitution Bench, would be a substantial question of law. It also describes in para 7 that when it will not be a substantial question of law, that if the question is settled by highest court or the general principles to be applied in determining the question are well settled, and there is a mere question of applying those principles or that the plea raised is palpably absurd, the question not be a substantial question of law. Now, it also describes that this will not be a substantial question of law. Now, this exception we find not only in Vinod That is the first judgment which I referred to you, which was passed by Hon'ble Supreme Court. That is Hero Vinod versus Sisamal. That was AIR 2006 SC 2234. But also a subsequent judgment which is considered to be a latest judgment passed by Honorable Justice Indra Banerjee and Justice J.K. Maheshwari in the case Chandrabhan versus Saraswati and others, 2022, Volume 7, SCR 295 page, para 33. Now, decision of this case was on 22nd December 2022. It says that a substantial question of law will also rise in a contrary situation where the legal position is clear. Now, this is an exception. In a contrary situation where the legal position is clear either on account of express provisions of law or binding precedents, but the court below have decided the matter either ignoring or contrary to such legal principle. In the second type of cases, the substantial question of law arises not because the law is still debatable, but because the decision rendered on a material question violates the settled position of law. Now, it is based on what? It is based on that the parties must get real justice according to their case, and if the lower courts below have misapplied the law, then in that eventuality the settled principle of law is misapplied, then in that eventuality the litigant will not be turned down away from the court. The Honorable Delhi High Court, sorry, I'm saying Honorable High Court, while exercising jurisdiction under Section 100 CPC, will have its power to intervene in such matter and to give justice and set aside the order of the first appellate court or the trial court by saying that the said judgment has misapplied the principle of law or has acted contrary to the settled legal principle of laws as laid by the Honorable Supreme Court or High Court itself. Now, another question is that sometimes the Honorable High Courts, while exercising jurisdiction in second appeal, that is under Section 100 CPC, it says initiate the de novo trial. Now, de novo trial to initiate, there must be pleadings to that effect. That it means there must be some foundation in the pleadings. Without that, it is not permissible for the High Court to order or remand the matter for de novo trial. Now, this judgment is pronounced by the Honorable Supreme Court in Sayeda Rahi Munusia versus Malan B and another, and that is reported in 2016, Volume 10 SCC, page 315, para 31 and 32. I tried to cover as many points as I could do, looking into my experience over the bar. I believe that my notes would be helpful to my learned friends. This is my purpose is to help the younger generation, the lawyers who are coming, to make them aware of the parameters laid by the Honorable Supreme Court. And I believe that I have done, but in any way, I will try to make out more videos on different aspects in near future. Thank you. Have a nice day. Grateful to you for patient hearing.